That girl Henny. Y'all gotta go to her channel.
The girl Henny, do you know who she is?
She a blogger or something?
Yeah.
Yeah.
Just like, where this lady come from?
Right? On your ass.
She on your life, G.
Shout out to Henny over there.
What's poppin', everybody? Welcome back to the bar. It's your favorite guys and Dr. That Girl Henny, and today we are pouring up on an update on the No Jumper Brawl. Dun, dun, dun. Yes, I know. This thing took place, if y'all do not remember, there was a horrific and gruesome video of men being pistol whipped and stripped down behind the No Jumper Studios in their parking lot. And that video featured Whack 100, Tremaine Ashley Williams, and a whole host of goons who decided that they were going to, I guess, test their gangster or prove their gangster on Jay Reed and his partner who rolled out there with him, Evan. Now, I know that there was some dropping of a name. I think it was of Mauricio or whatever. I don't know where that came from, but it turns out that his name is Evan Siller. Yes. So we have, lawsuits that were filed against Adam in the name of Jermel Reed and also in the name of Evan Siller, not Silver, but Siller. And so there has been movement in that case. But I also have some exclusive information that was given to me by Alex Alonso of Street TV. Shout out to Street TV. Shout out to Alex Alonso, because it appears that there has also been an arrest in the case that happened, and somebody is going to click city behind it. I know. I told y'all it was going to be good. Y'all should know whatever I'm coming to spill hitty, it's going to be hot, hitty, honey. So, without further ado, let me go ahead and get this screen the way that I like my screen, and let me not hold y'all up because maybe got things to do, places to be, and reports to put out on other things that are going on this internet, you see. So let's get into a little refresher, because y'all know how I like to do. I like to bring it back, then forth and forth. See, is this it? Nope, that's not it. Make sure I have the right one. It doesn't even matter. Let me just put this up here. So we have something up on the screen. Yep, I'm on the right one. Let me get this little watermark up here so that we can have our watermark. And I could get to reminding y'all of what's been going on. So in case you don't remember, because it's been a while, back in September of last year, the incident happened December of 2024. And in September, we had a court filing by Jermel Reed, aka Jay Reed. Now, I'm not going to get into all the other stuff that came out and that's been roaming about. We focusing on this, the No Jumper situation. So please don't bring any of that other stuff into the chat. Now, if y'all remember, he filed for premises liability, negligence, assault and battery, and negligent hiring / retention and supervision. And he filed against White Pickle LLC, Adam Grand Mason, doing business as No Jumper Podcast, Cash Jones, and Tremaine Williams, as well as those 1 through 50 inclusive. All right. And they go through the whole situation, and we're going to read it. We're going to read it just to refresh ourselves, because there's nothing wrong with having a little bit of a refresher. You know what I'm saying? So it says that the plaintiff, Jermel Reed, isn't at all times mentioned herein as a resident of the state of California. So this is the paperwork, and here are the general allegations. On or about December 26th of 2024, Jermel Reed, Jay Reed, was lawfully present at the premises located at 20. We know the address. I ain't even going to say it. When Jay Reed was violently assaulted and battered by agents, employees, guests, and/or affiliates of White Pickle LLC, owned and controlled by the defendant, Adam Grand Mason. Okay, so it says White Pickle and or defendant Adam Graham Mason knew or in the exercise of reasonable care should have known that its agents, employees, affiliates, and guests had a history of violent, criminal, and dangerous conduct and posed a foreseeable risk of harm to others. Now, this is where we're looking at this case, and this is sounding just like the Kenneth Lawson case, because Kenneth Lawson also accused Cash Money of the same thing. Like, you should have known that you had somebody that should not be out here dealing with the public. And the thing about it is, Adam knew that Jay Reed was there by his own admission. And not just Jay Reed's word. Okay. White Pickle and Adam Graham Mason were aware of complaints, law enforcement activity, or other indicators that its guests, affiliates, employees, agents, and or its associates created a dangerous and unsafe condition on the property. No Jumper has also been the site of a lot of different incidents that we have seen go down. We have seen pum-pums on set. Okay. People have run down up at No Jumper. No Jumper is, a space and place where people feel that they can, possibly be put into harm's way. But Adam would not be in this situation that he's in, being sued by Jermel Reed and also Evan, because if you would have conducted your business a little bit more properly, or possibly not continued to do business with WAC 100 after this, you would have then avoided some of these consequences that you are now facing. This has also been a space and place where, if you remember, No Jumper is also mentioned in the federal indictment of Big U. Why? Because WAC 100 bought Tremaine Ashley Williams, aka Fake Loose Cannon, Timu Loose Cannon, Dollar Discount Loose Cannon, Dollar General Loose Cannon, up there, and made some claims and some accusations that were going on his podcast. Okay, so it has become a liability to continue to do business with WAC 100. But Adam, I guess Adam don't see it that way, and he's going to learn the hard way. So, as you know, there was also a joint stipulation that was extended back in October on behalf of Jermel Reed. But then on October 27th, this is when we learned the true name of the other gentleman who was involved in the situation. And his name was Evan Siller. I keep wanting to say Silver. And now he also filed his lawsuit. Well, guess what, y'all? Jermel Reed on 5/11/2026, he filed in there for a declaration to be made. Now, this declaration that he asked for is where they send a bunch of questions to the defendant in the case, and the defendant is thereby required to answer said questions. Now, this document right here is 155 pages long, y'all. Let me just breathe for a second, okay? And so Adam and his attorneys received these questions that Jay Reed had for him. Some of these questions include things like, describe your personal involvement, if any, in planning, producing, approving, or appearing in podcast content involving Cash Jones or Tremaine Williams. So it's things like that. It was asking what, his primary languages, describe your personal relationship, if any, with Cash Jones during the relevant time period, describe your personal relationship, if any, with Tremaine Williams during the relevant time period, describe any agreements or understandings you personally had with Cash Jones relating to events or podcast content, describe any agreements or understandings you personally had with Tremaine Williams relating to events or podcast content, describe when and how you first became aware of the incident on December 26th of 2024, describe your actions, if any, in response to learning of the incident, identify all persons with whom you communicated regarding the incident on December 26th, 2004, describe all communications between you and Cash Jones relating to events, podcasts, security or guest access at the premises. Describe all communications between you and any third party relating to the incident, excluding attorney-client privilege communications. So you get an idea of what these questions were that were being asked of Adam. And let me just tell you, Adam did not disappoint, because to my amusement, I don't know how amusing it is for anyone else, but to my amusement, on questions like state your name, every name you have used in the past, and the dates you used each name, the response from Adam's legal team was, defendant objects to this interrogatory. Well, basically, he disagrees to interrogation. Don't laugh at me. I'm having a hard time today, okay? Because the First Amendment complaint was dismissed on March 20th, 2026. Now, there is no dismissal. As of today's date, March 25th, 2026, no amended complaint has been filed. There are no claims pending against defendant, and no operative complaint currently exists in effort to avoid needless discovery expense. On March 23rd, 2026, defense counsel requested a 30-day extension of the deadline to respond to these requests, given that there is no operative complaint at this time. Plaintiff's counsel refused. If a second amended complaint is filed and it survives demur, defendant will supplement these responses based on the pleading and claims that are pled. And so Adam, via his attorney, did not bother to answer any of these questions. All of the questions that were asked were responded to with generic objections, evasive answers, and refusals instead of providing real information. Okay. And it wasn't anything, there's stuff that was asked of him that, in all honesty, Adam could have answered. Okay. We all know the answer to a lot of those questions. The questions that were being asked of him were things that have already played out. You understand what I'm saying? We watched him get on a No Jumper podcast and have a conversation with Wack about the situation that happened. We watched Wack talk about, here's the text messages. We know that on air, Adam admitted to seeing Jay Reed on the premises, yet Adam continued to go on about his night. We've seen on camera that, matter of fact, I ain't got to tell you what we seen on camera. I ain't got to tell you what we seen on camera. Hold on. This right here is what we seen on camera. And we see down here, you've got Jay Reed and Tremaine and Wack. And this gentleman right here, Alfred Walker. Who is Alfred Walker, Henny? I'm going to give it to you in a minute. But we saw all of this basically play out. And Adam could have answered those questions because we know who he spoke to. We don't know if he spoke to anybody else. We don't know if he spoke to his attorneys, which I'm assuming that he did. But that is where we are with the civil cases, where basically everything that was asked of Adam, they basically objected to, did not give any answers to, and left Jay Reed hanging. Which now leads us to this right here. Now, I just mentioned Alfred Walker. Okay. And like I said, I know some of y'all are sitting back and y'all are like, who is Alfred Walker, Henny? Why should we know that name? Well, Alfred Walker. Oh, I don't want to show that. Hold on one second. Let me do this. Oh, you're not going to let me show that without that. Oh, I was about to say. So this is a better photo of who Alfred Walker is. And as I said, this is the man who was wearing the blue and white shirt. Well, what exactly did Alfred get himself caught into when it comes down to this No Jumper brawl beatdown situation that happened? Well, if you didn't notice, at one point in time, we saw loose cannon, or Ashley had a firearm, and Ashley was pistol whipping Jay Reed. But what a lot of us missed in this video was Alfred Walker. Yeah, Alfred had a pistol too. And Alfred was pistol whipping Jay Reed as well. Now, I'm going to be very cautious with what I share because I'm not trying to get into no trouble. Hey, YouTube, this video is for educational and entertainment purposes only. This is all AI. Nothing is real. It is all fictional characters that were made up for entertainment purposes only. So this right here over Jay Reed, that's Alfred Walker. And then you see there goes Tremaine. And of course, we all know the brutality that happened. And there you have, you know, Alfred is beating on, and in his hand, he has a pistol. Okay? And so he is one of the suspects in this case that was arrested. Now, this did not make a lot of spread across the internet. Let me get this up here for you guys as well, because I don't really think that a lot of people knew that there were arrests going on, and anyone who knew that there were arrests going on didn't want to say anything because they don't want to come off as a snitch. Come on, we know how this goes. All right. So, according to this screenshot right here, what Alfred is being charged with is serious. Okay, let's start at the top. Felony assault with a firearm on a person. Okay, special allegation of use of a firearm, one or more serious violent felony. He has one or more prior serious violent felony convictions, which means that he's a prior felon. So this is not going to look good for Mr. Alfred Walker. Okay. There's felony assault by any means of force, possible great bodily injury, with a special allegation on there of great bodily harm, and one or more serious violent felony. Okay, those are priors. So he's being charged with that. Let me get some more up here for y'all. Because I know y'all are probably wondering when he got arrested. Hold on. Let me get that information for y'all right now. Okay, so that was his next court date, but this is past. His arrest date was 5/6/2020. Oh no, that's not it. He was released on 5/6/2026. That was his next court date. Hold on, you guys, because I have everything. It's just a little jumbled. Permanent housing. That's still the next court date. Arrest date was 4/1/2026 by Burbank PD. So on April 1st, now you got to remember this incident happened all the way back in 2024. And Alfred is the first arrest. Now we could consider Tremaine to be the first arrest, but you already know he's locked up because he's locked up for that Big U, with that Big U felony case that is federal case that is going down. So he's already in custody, but this is the first person outside of all of that was arrested. However, he was released on ROR. How, Henny? I have no idea how that happened, but I do have an exclusive telephone interview that I did get with Alex Alonso. Now, Alex Alonso is of Street TV. Again, shout out to Street TV, the whole team, and shout out to Alex Alonso. He called yesterday and he gave me the exclusive information play-by-play of what went down yesterday with Mr. Alfred Walker. So let me get Mr. Walker back up here on this screen real quick. Let me take this down. And let's hear what Alex had to say played out in court yesterday.
So Mr. Alfred Walker was scheduled to appear in court this morning.
Can y'all hear it? Henny Glasses in the chat if y'all can hear it clearly. Let me know if y'all could hear that part that I just played clearly. All right, y'all can hear. So I'm gonna back it up and I'm gonna start it over.
Okay, so Mr. Alfred Walker was scheduled to appear in court this morning at 8:30 in Pasadena. Pasadena is going to be the courtroom where this no-jumper beating trial is going to take place. Uh-huh. It's the next closest jurisdiction to Burbank where this occurred. And what I learned today was that when he was arrested and taken into custody, he had a hearing in early May, and he was released on his own recognizance. He's on an OR release, which was very surprising to me because there are more ORs being given to defendants of nonviolent offenses. They had a $1.1 million bail, and this is considered a violent offense, but he was given an OR, but he has electronic monitoring as well. So that was interesting to find out that he is out on an OR. He didn't with a $1.1 million bail to get out, but he is under electronic monitoring. So that's the first thing. Second, his defense attorney is a bar panel lawyer, which means she's from the public defender's office. So he does have a public defender. And she told the court this morning that she's still waiting to receive more discovery on this case and that she wouldn't be ready to go on her hearing until July.
So he's going to be out on this ROR until July.
He's going to be out until the case is over.
Right.
Will probably be taken into custody, at that time if he goes to trial on this, or if he takes a deal, or if he's even offered a deal. In fact, that was one of the questions the judge asked. It's a little surprising. So early in this case, the judge asked the prosecutor, is there a deal being offered? And the prosecutor said, no, there's no deal at this time.
Well, I don't even understand, like you said, ROR on this type of a case and now a deal before you even begin the trial. Like that's so far away. Like the trial is not next week.
No, it's not. But this is a open and shut case because it's on video, unfortunately, for Mr. Walker.
Right.
The whole crime is recorded, so I don't know what type of defense you can even put up. So really, at the end of the day, it's going to come down to, do you want to plead guilty, and does the state want to give you a deal? But the state said, no, there's no deal right now. And that's done in an effort to save on resources, because to have to go to court and keep going to court and keep going to court on a case that's really a slam dunk, it wastes our tax money.
Exactly. So was Loose Cannon was not there for this court hearing, correct?
No, Mr. Walker was the only defendant in court this morning. No Tremaine Williams and none of the other defendants that are believed to have been either charged or have warrants were there either.
Interesting. Do you think that they'll be tried separately for this case?
No, I believe they'll all be charged under the same case whenever these guys are arrested. This Mr. Walker just got arrested in April, so he's the first one to be taken into custody. Tremaine Williams is already in custody.
Right.
So it's just a matter of time before the other co-defendants are arrested. That's my view of it. I believe that there are at least two more or three more people that Burbank wants to arrest.
Wow, and this happened in December, and he just got arrested in April.
Yeah, December of 2024, and here we are in 2026.
Right. I said it like it was last year. My bad. That was 2024.
Yeah.
Wow. Were there any of the victims in the case in the courtroom that you noticed?
No. Mr. Walker was there with his girlfriend and his mother. and there were no other people from the case that were there.
How did he look in the court? Did he look confident? Did he look nonchalant?
He just looked regular. I went up to him and told him I was covering this case. And he had a look of surprise that like why, or he didn't understand what I meant. But I explained to him I am covering this case for the media, and I will be here. Just give him a heads up. When he sees me inside that courtroom, who I am and why I'm there.
Right. Well, any additional takeaways that you have from today?
Well, the public defender and the prosecutor agreed that they would be ready for the preliminary hearing on July 7th. Okay. So that is going to be when the evidence is presented against Mr. Walker, and we'll see if there's other people in custody at that time. But it looks like, a lot of people doubted that anybody was ever going to go to jail for that meeting. Right. I know that I've said it multiple times on straight politicking, and even my co-host doubted me a few times. But here we are. It is a real case. It is taking place in Pasadena court, and preliminary hearing will be on July 7th, and I will be there.
So let me ask you this, because I just received information from the Jamel Reed portion of this, which would be the civil side of this same incident, where there were questions sent out. And, I know a lot of people really don't think that it was going to go beyond the civil, but even in the civil aspect of it, it seems to still be moving. Do you think that the criminal aspect will affect the civil cases as well if convictions are given out? Well, once convictions are given out, because there's no if in this at all.
Well, usually the criminal case goes forward, and once you get convictions on the criminal case, that makes your civil case much more powerful. But because these two guys, Mr. Reed and the other man, were beaten on camera, they really need to worry about the outcome of a criminal case. So that's why they're going forward with their civil case. And I don't think one is going to affect the other in this situation.
Well, I'm just, I'm surprised and not surprised at the same time. I'm surprised only because I was like you. I didn't think anything was going to come of this because it's been so long ago. But to see that the case is actually moving forward, this is being taken seriously. So as you guys can hear, this is definitely moving forward. So all of the other flim-flam foolery that was being spewed online about this not going anywhere, whack huffing and a puffing and blowing it down, that's who I'm talking about when I say that. It's a lie. And for those of us who thought that there was nothing going on, it looks like something was absolutely going on. Now, I see some of y'all asking about the police report. Now, this was pieced together a long time ago. We were able to get the police report in pieces. And yes, Wack was named on the actual police report as suspect number 4 in all of this. And there was some background that was given on who he is, also on Tremaine as well. So for Tremaine, it says that Williams is a rapper and a music producer. Williams admitted to being a member of the 8 Trays before eventually becoming a member of the Rolling 60s during a social media interview on January 30th of 2024. The 8 Tray Gangsta Crips is also known as 8 Tray Gangsta Crips or 8 Tray Gangsta, just the different ways they spell it. Williams is then it goes on, that's the repeat of things. It goes into describing the Rolling 60s. I don't want to get into any of that. It goes into naming Adam is the host of No Jumper podcast. The podcast focuses on interviews with underground mainstream hip hop artists and pop culture oriented guests of different careers and backgrounds. Graham Mason has hosted numerous admitted Blood and Crip to include subsets gang members on his show, some of which have been violent against Graham Mason or other people present at the podcast studio during the interviews. Graham Mason and Jones host another podcast together called The Adam and Wack Show, which appears to be associated with the No Jumper podcast. On this podcast, the two discuss current events, topics pertaining to people in the entertainment industry. Now he goes down and he does speak on, hold on Whack as well. He says Jones is a rapper, music producer. He's not a rapper, hip hop commentator, and record executive who manages several music artists. Jones, he manages one. Shut up, Eddie. Jones admitted to being a member of the Pacoima Pyrus Bloods with a moniker of Little Whack during a social media interview on December 6th of 2023. Jones stated he got jumped into the gang when he was 12 years old and still claims to be a member of the gang. And then it goes into breaking down the Pyrus. I'm not going to get into any of that because that is none of my business. So I'm not going to go there. Okay. But the premise and point of all of this is to show everybody that this is actually a case that is moving forward. Once again, it goes back to what I've been saying about Adam. You wouldn't be in this situation right now if it wasn't for your affiliation with Whack, and your continued relationship with Whack continues to pull you down. Now, if I were to play the full video in its entirety, you can't exactly say that Whack was not involved in this in some way, shape, form, or fashion. I still believe, as I believed a long time ago when this first happened, if y'all remember, I was asking who was in the trick bag. Was it Adam? Was it Tremaine? Or was it both of them? Because this trick bag was taking everybody down. And look, you've got Tremaine in federal click city custody, and you've got Adam jammed up in lawsuits. He is a liability, and lie. I want to lie, a liability. Okay. I wonder if Whack is going to offer to pay for Adam's attorney. You better not. You better not. You know why? Because he ain't going to pay them attorneys. Oh, y'all should have known that I was going to turn this into something. Y'all should have known we wasn't going to just stay here. No, because not only does Whack not pay the trainer, not only has Whack not paid the studio, not only has any of that stuff come down, but Whack has not paid the attorneys. Now, y'all should remember that I brought this up. I want to make sure that I give y'all the first document first and the second document second. Okay, so we gonna get to the first document first. Up here, cause baby, let me tell you something. You should have never got me started. You should have never got me started. You should have left well enough alone. Waukesha, 3-finger duty shooter. You should have left me alone. I might have gone easy on you. I'm lying. I wouldn't have. Because it's just something about dragging him that just really gets me going. All right. So what are we looking at, Henny? What you are looking at, and some of y'all may remember this case, but for those of y'all who do not, and Adam, if he is offering to pay your lawyer's fees, I would suggest that you do not allow him to pay them because he's not. He's not. Okay? Because this is Novin and Novin LLP. And who are they, Henny? Well, they are a limited liability partnership that is taking Cash Jones to court. Yes. They filed this back in 2025. And their complaint is for breach of written contract, common count goods and services rendered, account stated, and quantum merit, unjust enrichment. All right, so let's get into this right here because he don't pay nobody. Okay, he don't pay nobody. Plaintiff isn't at all times relevant. Herein mentioned was a limited liability partnership organized under the laws of the state of California. Plaintiff is informed and believes as such, informed and alleges that defendant Cash Jones is at all times relevant, was an individual citizen of the of Los Angeles. Okay. Now, plaintiff informed and believes. All right. So the first cause of actions was breach of written contract. Okay. So Novin and Novin, hereby referred to as incorporates, all right, on or about January 28th, 2021. 2021. And they did this lawsuit in 2025. A law firm entered into an hourly based written retainer agreement with defendants Cash McElroy Jones. McElroy, you being called to the carpet to perform legal services in connection with an initial matter. In entering into the agreement, Cash McElroy Jones agreed to pay Novin and Novin's attorney fees based upon their hourly rate as set forth in the agreement. Moreover, McElroy further enlisted the legal services of McNovin and Novin in connection with a secondary matter, Priscilla Rainey versus Jason Terrell Taylor. Dun, dun, dun. That's the games case. McElroy sought legal services from Novin and Novin on the basis of their pre-existing attorney-client relationship. So, McElroy, we're going to call him McElroy because I just like saying it because it just really fits him. Whenever I say McElroy, you know what plays in my head? That plays in my head when I say McElroy. I just think of a junkyard dog running around rabid. But I digress. Let's get back into this. Okay, so because of their pre-existing attorney-client relationship with McElroy, and because McElroy agreed they would be responsible to advance and or pay all necessary costs and expenses on time incident to the representation of both McElroy and the game, okay, in the matter, and to reimburse the lawyers upon their receipt of a statement for as much as said cost and fees are paid or incurred. So they were supposed to pay. He was supposed to pay the legal services, like that means travel expenses, whatever they had to come out of pocket and pay for. McElroy was supposed to pay them back and reimburse them. Plus, they were hired to defend both him and the game on an hourly basis. So for every hour that they put in working on any case, working on briefings or any of that stuff, they were supposed to get paid, okay? After McElroy enlisted Novin and Novin for legal assistance in the matter, Novin and Novin performed significant work on both McElroy and the game's behalf, okay? McElroy was informed on a monthly basis of the work and the accompanying fee statements. So every month they made sure they were sending him a bill, letting him know this is what we spent, this is what we've done, this is what we need to be paid. Okay. Novin and Novin has performed all acts, services, and conditions required by the agreement, as well as the matter to be performed on its part. In rendering the services herein alleged, Novin and Novin expanded time for legal services rendered and advanced and or incurred costs and expenses to be paid by McElroy. So it says that there is due an owing of an unpaid amount of $144,637.71 plus interest hereon at a rate of 10% as of September 8th of 2023. So they was doing work on both wax cases, the games cases since 2021. And here they are at 2023 submitting a bill to him, and here he's not paying them. What did he say to the trainer? Go ahead, file your little paperwork. I'll keep it tied up in court for 5 to 6 years. That's what he said, right? But you playing this game with some lawyers. I don't think that this is going to end too well with you playing games with people who do law for a living. And then it also says that there is a breach of the agreement, and they will continue to incur substantial costs at attorney's fees. So they are going after him and want him to be held responsible for the cost and the fees of everything. Okay. So if he's offering to pay your lawyer, don't let him pay your lawyers. Okay. McElroy became indebted to Novin and Novin for services performed by them, and for which McElroy promised to pay the reasonable value thereof. So you got the trainer coming after you for 12.5, and now you've got them coming after you. We just gonna round it up to the nearest dollar amount. You've got these lawyers coming after you for basically 145,000. All right, now let's get to this right here. You know, the minutes when they go to court. So these minutes were taken on April 16th of 2026. Novin and Novin versus Cash Jones. The matter is called for a hearing. There was no appearance by or for McElroy. Just didn't bother to show up at all. Didn't send no lawyers. But then again, how you going to send lawyers when your lawyers are suing you, right? So there's no lawyers that showed up for him, and he didn't show up. And the court and counsel for the plaintiff conferred regarding the status of the case, and pursuant to the request of the plaintiff, the case management conference held on 4/16/2026 is continued until July 16, 2026. And it's going to be in the Santa Monica courthouse. Now, that means that they have pushed this date back. Now, McElroy, I suggest that you put on your little leprechaun shoes and you grab your little pot of fake gold and you go down there to the courthouse and you go see what these people are talking about, because you really can't afford to be losing no more money, because these aren't the only people whose cases are still going. Okay. Now, while David Kaminsky might have been a punk ass nerd. Sorry, I shouldn't have said that. I've been hanging out with Dogface too much. I shouldn't have said that. David Kaminsky may have backed out of his lawsuit. David Kaminsky may have backed out of his lawsuit because he was, you know, a little intimidated. I'm going to say that. He was a little intimidated by McElroy, you know. McElroy, the leprechaun. You've also got the Kenneth Lawson case that is still carrying on to this day, because he also has to return to court this year for that case. And now you have these lawyers that you're going to have to go see in July of this year. So the debt just keeps on mounting. You just don't. He is the epitome of I don't give a fuck what you say. I'm going to do what I want to do. I don't care what I agreed to. I don't care. That man's word is worth the turd in the toilet. Yet y'all keep going over there and y'all keep doing business. See, the problem is, I think people don't believe until you make a believer out of them, McElroy. I don't think they believe. Oh, okay. What's popping? What's popping? Smoked out, coming in here on different pages. I'm just saying, you know. So, Adam, you're next. You're already in the trick bag. You might as well get snug as a bug in the rug. Oh, and I'm not done. I may not have come every day like I originally said that I would, but you've got to admit that all of this is also very interesting. Especially what I find really interesting is the fact that people continue to do business with Whack even after I have gone through all of these court docs that show that he is a bad business partner, doesn't keep his word, doesn't pay his bills, and he is a horrible horrible manager. because the game done lost his house. Blueface's house got a lien on it. The game's career is over. Blueface's career is going that way. 6ix9ine was working with him for a little while. 6ix9ine ended up getting arrested by the feds for the IRS stuff that he got into. Everybody that deals with him takes a loss but him. So at this particular point in time, because I've been standing on wax neck with these court documents, you know, using what he say as a weapon against him. Y'all already know my history. I don't have to get on here and be braggadocious about what I do or what I have done, because I've put my feet so far in this sector, it don't matter. Even though mofos want to take shots at me. Pow-pow. Nigga, get over there, little nigga. Anyway, I've put all of these court docs out before. And the reason why I'm continuing to bring these court docs out, or decided to bring these court docs out again, is to refresh everybody's memory as to what I've already put out here, because not everybody was paying attention at one point in time the way that they started to pay attention. And when people started paying attention to all of this, sad to say, is when the no jumper brawl happened. And then after the no jumper brawl happened, people really started paying attention when the Big U case came down. Because by then, everything that people had been out here in these streets, shout out to everybody who has stood on Wax's neck, his head. I don't care if you stood on him pinky toe or put 3 fingers up his duty chute. Salute to you. I don't know what's wrong with me today. I don't know what's wrong with me today. But if you have been standing, then continue to stand. And no, that was not a shot. It was a joke. So don't go saying that it was a shot. It was a joke. Did you hear about the sexual assault on Blueface Tour Bus? Yes, I did hear about that. And I'll be talking about that on my other channel. But right now we're talking about whack. We're talking about whack and no jumper. So y'all, what do y'all think? Do y'all think that the others will be arrested? And do you think that Whack is going to be one of those people that end up going to Click Click City, or at least having to appear in court somewhere? Because, you know, we all placing bets on him showing up to Big U's trial and having to testify as a witness. But now with this no jumper brawl taking a criminal turn and him being named on a police report as suspect number 4, do y'all think that it's only a matter of time before he be putting on them silver bracelets and being brought in for questioning? Because this ain't no internet game no more. Because last I checked, when somebody is a suspect in a criminal case, everybody involved has to come in. And if he doesn't go in as somebody who participated in the brawl, he was definitely a witness. You know, witnesses get subpoenaed to come into court. It would be interesting to see if he's going to go in, what he's going to say, what are you going to do? In the meantime and in between time, you better get to digging in that pot of gold and the golden chocolate. You know, remember the little gold coin chocolates we used to get at Easter? That's what his McElroy, the leprechaun, that's what his pot of gold is full of. Chocolate golden coins. So you better keep digging till you find one that's real, because, oh yeah, don't forget, Kim is on his head too. Hold on one second. Let me give you an update on that, since we over here and we talking about this. It's nothing major. It's nothing major. You know, just a little update. A small one. Just a small one. Because let me close some of this down. I don't need this. I don't need this. I don't need this. Give me this. Put that up there. Hold on. Let me give you a little bit of an update, because we've got motion on this baby. We had a little movement, just a little bit. Boom. Hold on. All right. So let's get into it, shall we? So this is the latest filing on the divorce between Wack and Kim Kim is dead set. She wants out. She said, give us a free. Now, he got to go to court. That's funny. Oh, Wack, you're going to be spending your whole July in court. Did you know that? He's going to be spending his whole July in court. Hold on, because if I'm not mistaken, not only is the Novin and Novin in July, I believe that old boy's case is in July too. Hold on, let me pull that up too so I can make sure I got everything. But while I'm doing that, let me tell y'all what's going on with Wack and Kim. They have a trial date that is now set. Okay, Kim is not playing. She wants out. Okay, she wants out. And so they'll be going to court. I believe that says, because I'm not looking at the screen at the moment because I'm trying to see. Oh, no. He goes to court for Kenneth Lawson in September. Okay, so boom. They'll be going to court on July 14th for the divorce. Okay? To all parties and attorneys, you are hereby notified that the above matter has been set for status and trial set conferencing. All right? You must appear in court on the above date and time. All right? A request for trial setting conference has been filed. At the trial setting conference, the court will inquire of all counsel and the parties with respect to the issues involved in the case, the need for discovery orders, the time needed for trial, and other procedural issues. The court may issue orders on any of these subjects. Additionally, the court may set the matter for mandatory settlement conference and trial, defer setting these hearings to a later date, or take a request off calendar. Counsel and the parties shall comply with Los Angeles Court Ruling 5.13 and 5.14 prior to above hearing. Trial counsel and parties shall be personally present at the trial setting conference unless otherwise ordered by the court. So that means can't nobody show up via electronically. All right. All persons must be present in person. Boom. Cherry Blossom, she gifted a membership. Whoever got the membership, make sure you tell Cherry Blossom. Thank you. Thank you for gifting a membership, Buki. Oh, for the members, the transcript reading for David's first appearance in court is in the members right now as we speak. So yeah, Kim is not letting up. She wants out of this marriage, and I do not blame her. Okay, if you remember, I already told y'all when it came down to that Kim had filed, the courts denied her, like they turned that down to reactivate the divorce. And Kim did not give up. Kim said, I'm not staying married to this man another minute longer. So it looks like this divorce is going to be rolling down the river right along with everything else. Kim, girl, I don't know if you're going to have anything to get from him. I don't think he got no spousal, no support. I don't. R&B, run. The sink is shipping, girl. The sink is shipping, run. Just saying. But anyway, that's going to do it for this spill. Hopefully this was informative and you guys were thoroughly entertained while you were informed. I shall return with more court docs because I rather enjoy them. Don't you? Y'all make sure that y'all lean on a like on the way out. Share this video up. I appreciate each and every one of y'all. Have a high vibe. Remember to vibe high so the bullshit don't stick. Okay? And have a prosperous day on purpose. And I'll see y'all in the next one. Peace, everybody. Because I don't want